Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom. Before we start today, a trigger warning to anybody listening that we'll be discussing domestic violence and family violence. So if you don't feel that you're comfortable yet to listen to an episode on this, skip it, and definitely don't listen to it with children in the car. Are you or your children being exposed to family violence? This episode is going to be for you. We are tackling a topic that is not much talked about, but it is how domestic violence and family violence can affect your children's matters in the family court. Remembering that there are 2 different courts. One is the domestic violence court, one is the family court. And then we'll be talking about the 5 things you can do to help the court understand the impact of that family violence on the kids and on you. Welcome, Mum.
Hello, Laura. Hello, everyone.
Now, this is a meaty subject, and of course, again, disclaimer, if this is general advice only, which means you must go see a lawyer.
Yes.
Don't rely on any of this information for making decisions for your individual cases.
Yep. And the domestic violence courts in each state are different,
yes,
but none of them is associated with the family court. So
yes,
2 different courts.
So we're talking about the family court, Mum.
Yes.
And I know we've talked about this in other episodes, and I'll put in links in the show notes to all the other domestic violence, family violence, coercive control episodes we've done. So if you are experiencing that, go and listen to those as well. But this is about not the domestic violence part of court in another court, because the states look after that. This is about the family court.
Well, to give it its proper new title,
yes,
the Federal Circuit and Family Court of Australia, or the FCOA. Such a snappy little title.
Yes.
Snappy little name.
But in that, they don't do the protection orders, the AVOs or whatever they're called, or DV things.
The court has power. The family court has some power to order someone to be of good behaviour towards another person, but it doesn't often do it because the state courts really have that jurisdiction covered.
Okay. Now, I think a lot of people who have not been in the family law system or don't understand, have never gone through, no one really watches TV shows about this sort of stuff.
No.
They just assume, there's family violence or it's DV, then obviously the other parent doesn't see the child at all. And that's a myth, isn't it?
It is.
It is an initial, straight off the bat, just because there's domestic violence or family violence.
Yeah, that's right.
Doesn't
automatically mean no time.
Yeah.
Sometimes it does mean no time with the parent, but it doesn't automatically.
So it's kind of the person's job then, whoever it is, who's the safe parent,
yes,
to do these 5 things that we're going to talk about to show the court, come on, guys.
Yes, to show the extent.
This isn't safe.
And to help the court make a decision in the best interests of the children. So you're the children's advocate in this, so you've got to try and put aside your I can understand people being absolutely devastated by domestic violence, and it may have been the thing that made you separate in the first place, but the court doesn't hold the view that domestic violence means an end to the relationship between the child and the parent. So it's a tricky field.
Now, there's safeguards that the court seems to think will help in regards to that. You were saying before we start, the court is of the view to an extent that once the person's left the family thing, that the violence doesn't continue.
Well, that's certainly been a view, that there's been this concept, I think it's still around, that some of the violence, family violence, which is, let's face it, physical and emotional and psychological abuse and financial abuse, sometimes the court's of the view that only happened, it's situational because you were separating, and that now that the heat's gone off, maybe that stuff is a thing of the past. Okay. And it's really hard for a person who's been through family violence to accept that and to then send their children to the person who they are avoiding at all costs at the moment, because the court's very active in keeping victims, the adult victims of family violence, away from the perpetrators, and there's some really good systems in place now. But I personally think the court could do better in terms of protecting children. But there is a large body of evidence, and I'm not a psychologist, general advice only anyway as far as law, but everything I read in the Institute of Family Studies, the reviews that come out, seems to say that if the relationship with the abusive parent can be managed so that it's physically safe and psychologically safe for the child, then it's better to manage the risk and have the child go than have the child grow up without a connection to their parent, their biological parent. And that is the balancing act that the court has to do. And really, it's really hard as someone who was subject to
it.
No, I didn't.
No, you were subject to it.
Yes, subject to family violence. I've been there. I understand all this, how it felt. It's really hard to accept that someone you wouldn't go near ever again is someone that you would send the children to, and this concept of an acceptable risk, and that the risk could be somehow mitigated or reduced by if the other person doing something. Yes, and that they might have to go to counselling.
So let's talk about that. So the court safety guards seem to be things like going to counselling or contact centres, but that's short term.
Yes, they send both parties to counselling.
Yes,
in case the problem is you.
Yes. God, that's like the Taylor Swift song. It's me. I'm the problem. It's me. And in those, I hear those stories where they say, but they told me it was my fault because I made them angry, and that's the physical side of things. But it just, and I think the court sending them to counselling is like saying you are part of the problem, which is hard to swallow. Yeah, but let's not get digressive.
No. Okay.
So what I wanted to point out, you were saying about this risk thing. So how does the court? So it's domestic violence. The court doesn't determine violence, do they? They don't sit there and have a trial on whether there's family violence because that's the other court.
No, they do. They do? I mean, it's a big part, because remembering that the structure of the Family Law Act about kids is that the objects of the act are that the kids have the right to be loved and cared for by both parents, and then the two primary considerations are, one, that the children should have a good relationship with both parents, and two, a second one is to protect the children from physical, psychological and emotional harm. So the court has to explore those issues.
Okay.
And the court has to make findings about them, come to a decision about them, because the third part of that, in relation to those two primary considerations, relationship and protection, if those two things are very finely balanced and there's a need for a child to continue a relationship with a parent who they may love, compared to the risk, then if they're exactly equal, the court has to decide to protect the child and not send them. But they make a decision really about, is the risk to the child so great that they should have no contact with their biological parent.
So that's what that risk thing. So it's unacceptable risk
or risk, yes.
Or risk.
And
so so can you explain? So family courts sit down and they decide, okay, so if someone raises and says there's family violence, it's happened in the past, does the court have to then go either they're an unacceptable risk or a risk? How do they decide that?
Or no risk.
Or no risk.
So they're the three options. They take in evidence, hear people in the witness box. You have to produce evidence.
And we're going to give you our 5 tips.
5 tips, yep. How you present, what you present. They will, presumably someone will subpoena the police records and so forth. So the court, whilst there's that, you can easily convince them, no, you can't easily, but you may have evidence of what happened before you separated and the violence. They also seem to need something to show that it's going on.
Right.
And also, if the other person, having committed violence, family violence, doesn't try to get any help. So, that might be an unacceptable risk.
Right. Okay. So the court has to decide whether the person who's committed violence in the past is unacceptable risk, or just a risk or not a risk.
That's
and
right.
then they make their decisions on parenting time with the child based on that decision.
Yes. So they do have a concept of kind of rehabilitation. If a person acknowledges what they've done and they show willing to get some treatment, then that really can reduce what would have been an unacceptable risk to just
Can I ask a question, though? Is that literally just what every person who's been accused of family violence just goes into court and says, oh, yes, I'm sorry, I don't want to do it again and I'm trying really hard? Is it pretty much... Oh, no, are there people that go in and say, I'm not a bad person?
Probably 50-50.
Right.
So if someone's done something wrong and they're humiliated by having done it, you would expect them to automatically go and get help and try to change their reactions.
Yeah.
It's cynical of me, but sometimes if a court has to make an order that a person who's done something wrong must go and get counselling, I would point to that in my submissions in the final trial as evidence that they haven't taken it on board.
If you have to be ordered to go do it.
That's right.
Yeah.
They're just like a 2-year-old saying tar to make you let go of the biscuit.
But that's the court's way of ticking the box saying, I've done my duty by making sure the kids are safe and not because they're going to see a psychologist.
Yeah, well, that is one of the ways. But I don't think the court at a final trial, I don't think it's that cynical. I think it's them trying to do the best they can.
Okay.
See, what they used to say about family violence is it's the easiest thing in the world to allege because it generally has happened behind closed doors. There's hardly ever anyone else there. And it's the most difficult thing in the world to rebut.
Yeah.
And, sometimes just by the look of a person, if they're ex-army, big bloke, and the lady is diminutive, little with floral tuck shop dress on, it's very easy for the court to go, and it can be like people can lie. So anyone who's alleging family violence and are wondering why the court isn't taking it seriously has to remember that many people shamefully have just used it as a tool.
That's terrible because I guarantee you anyone who's listening to this is probably thinking, but it's true, it's happened to me.
Yeah, good.
And I know that maybe those people, because we've met some and we've spoken to some, it is one of the struggles they have to deal with is asking themselves, but it did happen. Am I crazy?
But when I went through court decades ago, there was no domestic violence legislation anywhere in Australia.
So it's getting better.
And the thing was, if he didn't or she didn't hit the kids, then
it doesn't matter.
It doesn't matter. So we're moving slowly.
Okay.
But there's practical things.
Yeah. So let's look at the practical things that your top tips, but always get legal advice, okay, of how you can help the court understand the impact. So if it is something that you're urgently wanting the court to understand, there's ways to go about it and there's ways not to go about it.
And then if you've put your best case to the court and the court still decides it's an acceptable risk,
yes,
the term grates for me, then you've done your best. Hopefully the court officer or judicial officer's experience about how these things play out long term might help. At least they've got that information, and if they still make a decision about their children going to the other parent, then you'll have some comfort in knowing that they're applying their experience and you've presented your best case for the children.
Okay, so let's look at these things that anyone who's listening today who's going through the family court and has experienced family violence, and this is separate to getting a domestic violence order or anything like this. This is all about, how the parenting is going to continue into the future. So some of the things that you've said, Mum, number one is focus on the impact of the children. So basically what you're saying is the court doesn't care. And I know that's hard for people to swallow as well. The court doesn't care about the impacts that happen to you, apart from perhaps maybe if it impacts on how you parent.
Yes, I think they need to know about it because it also shows the tendency of a person to be violent. So you put that in as a history, but do it quite matter-of-factly. I actually like to put it in a list.
Okay. Oh, wow.
And try to put a date and the event and whether the police were called, child safety, who intervened, put that in a list so the court is under no illusion of what actually happened. And if you can't remember dates, then you'd say, pulling my hair and other things that they did. But then you need to focus on the kids, okay? So the impact on them. Yes. So if you had a fight together, and there was violence, and say a hole punched in the wall or plates broken.
The kids saw it.
The kids came out, what's going on?
Well, that's physical. What about how could it impact the children if it was emotional?
Okay, so what if a person wanted to go to the doctors or go to visit a family member and the abusive parent, the controlling parent, keeps the keys or... they miss out on a party, which is also violence if the kids miss out a party. So you talk about that. So those things, like depriving of money, depriving of time with family, liberty, isolation,
freedom.
Yeah.
So have a little think.
And emotional abuse, remember?
Yeah. And focus on, the children, because in the end, that's the decisions that the judge is making on is really the children and the impact of whatever they decide is what will happen on the children.
Yeah. And also I think the family law, the DV Act, Domestic Violence Act in Queensland, lists examples and it includes the children helping to clean up.
Yeah.
That's exposure to family violence, clean up after the mess, comforting a parent after a fight like that, seeing the police come, seeing the ambulance come, hearing raised voices, all of those things, or one parent with an injury that's obvious when they're dropping them off at school.
It's so easy though for physical, but it is much harder, for emotional and financial to show how that impacts on the children.
Yeah, well, it does though. They don't have their school supplies, or they're not allowed to go to camp, or you only get a certain amount of money, so you can't do these things with them, or you have to ask every time, and they maybe say that the child can't go right up till the last minute. And coercive controlling conduct can impact on everybody.
Yeah. Okay, we might put a list in the show notes of websites that you can go to
get some examples.
To get some examples.
Yeah, because a lot of people with coercive control don't realise they're in a domestic violence situation.
Until someone starts reading it out and saying, what about this? Oh, yes. What about this? Oh, yes.
Yes, and the T thing, put the T thing in as well about consent.
Would you like us to take away the overwhelm of the divorce process and give you the step-by-step guide on what to do at each part of the process and show you how to do it? Even giving you the correct wording and legal templates that you can use for your property or parenting agreement? Would you like us to show you how to do your own negotiations and mediations and keep it out of court? Well, then you're invited to the DIY Divorce Blueprint. It is the only training of its kind that shows you exactly how you can do your own divorce, property and children's settlements, mediations and negotiations so that you can finally move on with your life without having to spend thousands of dollars on lawyers and years in limbo. Go to www.thedivorcecourse.com.au/enroll to find out more today. Join us now.
The other one that was really important that you pointed out that maybe a lot of listeners don't know is to help the court understand on what's happened after separation.
Yes.
Because like you said, the court kind of seems to think that it'll stop after or the heat comes out of it.
Yeah.
So if the family violence continues in one way or another after separation, that is important to point out to the court to say, look, it's still happening.
Yes, or she, but usually he is still angry, enraged, that part.
So through text messages, stalking.
Comments, tone of voice, insisting on things happening a certain way. Again, withholding money for you, withholding reasonable agreement for the kids to do stuff.
Yeah.
Just sort of so you show the court that even though it escalated at around separation, you're still separated and it's still making that other person angry.
Yeah. Okay. Number 3, making it matter of fact. So what, just focusing on the facts?
Yes. It's try not to use words like incredibly, unbelievably, terrified, sobbing. Try
Completely,
to be, so try
every time.
Yes, so just
Always.
be matter of fact. And again, it's kind of like a little list. And when you notice, use the incidents. Don't you could say she always made me feel guilty if I went out, so I didn't used to go out. Instead of that, say she didn't let me go to golf, as in she took the keys to the car, or she wouldn't let me go to golf because she threatened to, take the kids and leave. Not speaking to someone is a really big red flag. And often if someone hasn't spoken to a person for a long time and then the person leaves, then suddenly they want you back. They want to talk about it and all of that. But the court is really getting much better at recognising the ways in which control manifests itself.
But what's important in this point is to make it matter of fact. So the wishy-washiness of saying, and I understand it must be hard for people to think back, oh my gosh, what's happened? It's all been a blur, but really think about it. Okay, what are some incidents? Maybe ask your friends, say, hey, when are the sometimes you've seen that that controlling behaviour or when I've been in trouble?
Imagine you've got the words for instance before each one and give the court some examples. Again, like I say, for writing a good affidavit or anything, you need to show, not so much as tell them what happened. Don't interpret. Say, like if you had a fight and you fractured your arm because someone threw a doorstop at you, you would say on this date, he picked up and threw, and we were in the lounge room at the time, the kids were here at the time, this happened. As a result, I had to go to the doctors and here's the x-rays. Like, just really keep it practical.
Yeah.
And that helps the court understand how it was.
And I guess it'd be really hard for a court if you just say, this, and sometimes he did this to me or sometimes she did this to me, but there's no evidence.
Yeah, or worse, that you use the words family violence. The most useless line I think I've ever seen in an affidavit, not one of ours, was he frequently committed family violence.
Okay, so that's a waste of time.
But, yes.
Well, it doesn't really show anything.
It's an assertion without proof.
Yes.
And, of course, the other person responds, I did not commit family violence.
So what would be better was, on these days, this happened, this happened, this happened. And the judge can go, oh, that's family violence.
Yes, and here's the proof. So, he only let me have $100 a week. Yeah. Here's the proof. Here's my bank statement.
Okay, so let's having a look to help the court understand, focus on what's happened after separation.
Yes,
definitely.
as well.
Then focus on the impact of the children. Make sure make it matter of fact. And then we have two others, that's documentation. So I know we kind of just touched on it, but documenting anything that happens afterwards, any interactions that are violence.
Control. You'll take a while to realise. Like it's really, I think it's in the Bible, they talk about the scales fall from your eyes and a lot of stuff you were prepared to put up with in the relationship and shortly thereafter. As time goes by, as a famous person once said, you go, well, excuse me, hang on a minute, you don't get to... And so you may have to go back and fill in some things that you didn't think were important at the time. Now, there's a couple of reasons for doing that documenting. One is it's a contemporaneous, like done at the same time, usually, for the court and for reference to things. But also sometimes when you tend to minimise things, you say, oh, it wasn't that bad, or you might have even blocked it out.
Yes.
It's only when you look at the cumulative effect, when you go back and read the document and see it as a pattern, it will stop you going soft on it and feeling like it wasn't that bad. It'll stop it just helps keep it real for you.
Well, not only that, I think if it's your lived experience and you've been living it for years and years and years, you probably handle it a lot better than someone who's never dealt with that kind of behaviour. But if you present that to a judge or a lawyer and go, okay, well, this is what happens on a daily basis or a weekly basis, they're going to go, holy moly. Whereas to you, you'd be like, I've been doing it for months. I'm kind of used to it. And that's what people do get used to it. That's how coercive control creeps in.
That's right.
Because they just start a little bit and then a little bit more and a little bit more to the point where then you're just used to it.
It's what you put up with out of love, usually, and then that creeps.
So documenting is a great idea. Also, I think for a lot of people that I've met going through divorce, everything's in the air. Their lives are upside down. Their whole world is unstable. They don't know what's happening. They don't know who's going to live in the house. They don't know when they're going to move. They don't know who's going to have the kids.
Yep.
The last thing they're going to remember is every instance of family violence to write down to remind the judges in the future. So you have to do it because otherwise you'll forget.
You will. And often when you ask those friends, they'll go, oh, well, I was horrified the time he did this or she did that to you. And you go, oh, I hadn't even thought about that.
Yes, yeah.
And people have like revelations of examples of the very poor behaviour and how low they set their own standards to accept it. For years, I'm not a psychologist, but I do think there's value in that journaling as well in terms of healing maybe.
Yes. Okay. So, Mum, with documentation, you did say in another episode, I think, that if you are going to say to the judge, here's some copies of my diary that show...
Yes.
To be careful because they can ask for the whole diary.
Lot. Yes.
Have you ever had any cases where that's happened?
Of course.
And
yes.
Been bad?
Yep, that's right. Yes.
Yes.
It's been terrible. So I don't do it, of course, but sometimes the other side does, and I go, oh, well, that's an incomplete record. Please give us the entire diary.
So then you have
and then
whole
you've got
diary.
Everything. Yes. So
the last thing you want is a family violence ex reading your diary.
I know, because it's just a continuation.
And they probably would love it.
And the court may say, yes, they have to. So keep a separate one.
Right. So
it doesn't need to be a diary. Like you can have a diary for the current that's just for rubbish, a little black book.
Just get a $2 shop
$2 shop, little tiny one.
Dot points.
Yep.
And only write in the family violence thing.
It's also very good for writing who had the kids and who didn't.
Yes.
And all of that will be the only thing that you would ever reveal to the other side because your own personal diary is hardly relevant.
Yes. And in saying
don't
that
refer to it either.
Important. Yeah, don't refer to your personal diary, otherwise you might end up having to give it. But putting in your diary who had the kids and when can also help.
Yes.
Not domestic violence-wise, but in the future for custody issues as well.
It will. And sometimes there's a relationship between the abusive phone calls and when they've got the kids. Or is it happening while they've got the kids? How's that work?
That's true.
Did they yell? Could you hear the kids in the car? Yeah.
Okay, so we've got be matter of fact, document it, but be careful where you document it. Focus on what happens after separation as well as what happened during the cohabitation. And focus on the impact of the children.
On the children, yep.
And then lastly, and this one I hate even saying it, and it's sad, but you've said make sure the court doesn't view you as a hyper-vigilant, over the top. And is that just a tactic? Is that what the court, is that something that happens a lot?
Well, it's been happening since the 80s, and the court, it's kind of a half compassionate but half not. It's kind of, we understand what you've been through. It's terrible what you've been through. But of course that would make you extra anxious and it's just your anxiety. It's not really that bad for the children. So and if only that person will go for counselling, everything will be fine. You know what? Why don't both of you go to counselling so you can understand your experience? And it's kind of patronising.
Kind of. But I understand maybe some people are hyper-vigilant and anxious and it does affect
because they've been through a lot.
Through hell.
Yes, that's right. So try to keep that out.
I hate the idea that women or men have to hide that or be
criticised
accused of it.
Yeah, I was accused of over-involvement with the children.
I know a man who was accused of being paranoid or hyper-vigilant, worried.
Yeah, so it's a nasty little term.
Yeah.
However, you need to avoid it, and the way to avoid it is by not going, I guess, get someone else to look at it and say, am I being a little bit too
far
worried here? Have I drawn a line too far? Because there's kind of a pendulum with domestic violence, and one is where you'll tolerate all the domestic violence, and then as you gradually come out of it, the pendulum's swinging away.
Yeah.
And then the pendulum swings sometimes past normal and to a further point where you think the other person's all powerful, and that everything they do is a further assault, because it's not just the first time, it's an adding on to what they've been doing to you for years. And the client then I have to talk to people then and say, well, hang on a minute, we just need to, are you seeing this through your DV eyes, which is terrible, but we don't want the court to say, too much, too over.
So even though it is completely fine to be a person who has been exposed to family violence and then is reacting to family violence and dealing with family violence, and that makes complete sense. But what you're saying is, in the family court, if they make that an issue,
don't give them any fodder for it.
Don't give them fodder for it.
Because that's a response. Oh, she's over careful. He's just super anxious. It's his personality.
It breaks my brain, though, because it's basically saying this person's caused family violence to this person, and now this person is broken by it. So therefore, this person should have the children.
I think that we're asking the wrong question there.
Okay.
So the kids have been witnesses or exposed to family violence, and now they're with the parent who would have been obviously and understandably affected by the domestic violence. What is the right thing to do for the children? And the parents can fend for themselves. So it is hard.
It's about the children.
It is.
But so what really any listener out there needs to know is you need to make sure that you are taking care of your recovery, your journey.
Right.
Because that can be used against you if you struggle.
Yeah, yes.
Which is insane.
I know. It seems so cruel, but it's not a court of justice so much. It's like the court's manifesto or their aim is to make orders in the best interests of the children, which will help them grow into the best version of a human they can be. And the studies are showing, that I've read, have showing that children who don't see one of the parents have a much higher risk of drug and alcohol abuse, unable to form proper relationships in their maturity, can form an idealised view of a parent if they don't see them. As Judge Bell used to say, the child needs to know their parent warts and all. Yeah. Because if you were still a couple, they would know the parent warts and all.
So you go through the court process. You've tried to help the court understand the impact on the children. The court makes a ruling. Maybe they're, So what kind of safety guards are in orders to alleviate anybody's worries if they are a subject of family violence and they're worried it will continue? What kind of things do courts do?
Well, the court can make orders that have gradual time to see how the potentially abusive parent interacts with the children, rather than suddenly having them 50-50, but give them smaller amounts of time that might not trigger their anger and see how that goes. They may make orders, at least in the short term, that the persons be supervised and someone watches them interact with the children. The fatal flaw in that arrangement is that
they know they're being watched.
It's helpful for the kids to see their parent because it's safe, and so they can develop their relationship. The issue is, it's supervised for the very reason that it will help the parent behave themselves. However, then they write a report about the conduct of the person having supervised time and say, oh, they were wonderful, they were perfect, they didn't show any signs. Well, of course they didn't.
Because they're being watched.
They know they're being watched.
It's like having the principal in the room in a classroom.
So the only person for whom a supervisor's report will show negative is a person who literally can't help themselves. Yeah. But most manipulative, controlling, or they're not violent, or the high conflict. They're not violent in their day-to-day lives. They are aggressive towards it's why it's called family violence.
And it's controlled.
Yes, and they know how to stop it, which makes my blood boil. And so they know how to stop it in front of a contact centre supervisor. And sometimes the supervisors are completely taken in by how well behaved they are. But if you look at it as a way for your child to spend time with the parent safely, so they grow up to be the best version of themselves, it works.
Yep.
But unfortunately, lately the courts have been saying it's not a solution long term for the children to have continual 100% supervised time forever and ever. And so it's used sometimes while the kids are little. It's used before the final trial just as a safeguard. So supervise. Sometimes that's an external supervisor. Sometimes just the changeovers happen at the contact centre. You can arrange that. Sometimes a family member supervises so that such and such spends time with her mother / or her father, provided all such time is in the presence of, and you put one of the grandparents in or something, and they'll give an undertaking to the court. So that's another way of doing it. So supervised, sort of family supervised, structured orders, a little bit of time, and then gradually build up. Or no time at all. Or cards and letters, or only videos, or only phone.
Is that what happens if they do the little step-by-step increments and then there is an event, there is a family violence event with the children? Does it then go back to court and then it's turned to no time?
If they've made a little step-by-step in an interim order, it's not really practical. If it's final orders and the step-by-step is progressing, the court has obviously decided that that's going to be okay. It would have to be something very significant for you to take that back to the court. And remember, good old Rice and Aspland has to be a real change. And so you can't just get the orders and go, oh, I don't like those. I think I'll go back to the judge. No, your file's closed. You've got an appeal or you've got nothing.
So Rice and Aspland is a case that everyone uses as a standard on whether you can go back to court once you've got final orders, and that is what?
The standard is there has to be a significant change to warrant the reopening of the case, because the overriding view, and it's been this view since the 75 when the Act was enlisted, is that litigation is bad for children.
Okay.
And so they're not going to let you keep putting them through it over and over again.
But family violence is bad for children.
It is, my darling.
It drives me insane,
I
Mum.
can see.
I hate the whole situation. And I think anyone who's listening, the best takeaway you can take from this is those guiding ideas, and that is focus on what happens after separation, document it, focus on the impact of the children, make sure the court doesn't take the view that you're some hyper-vigilant, neurotic, crazy lady, and be matter of fact. And I think if you work on those things, you give your child the best chance of getting the best outcome. But you know, it's a huge topic, and I think this episode really, we just wanted to let people know, because there's a myth going around that if there's family violence, the children don't go back to that person, but that's not always the case.
It would seem like the common sense answer.
Well, that's what everybody who's never been in court assumes, I think.
Yes.
Well, most people.
Yes.
But so I think it's important to let these people know, and anyone listening, you know, these are the things you can do. And of course, we've got the other episodes to talk about the things you can do to help yourself. But this is to help your children in the court matters moving forward.
And you've got to sort of be a really good actor and do your crying in the shower and be positive for the children.
When you say hard. Being a good actor, not in court, you mean around the kids?
Around the kids. Yeah. You have to honestly make it like it's fun. Oh, you sing Daddy, that's great. Or you sing Mummy tomorrow, you know, and be a support person so that they're really oblivious to what's going on for you. And we are really sorry that you're going through this.
Yeah, it feels horrible to even have to tell people this kind of information, but education and information is power.
It's power, that's right.
And if you don't follow this, you know, the outcome could be worse.
Yeah, general
advice only. So you must go and see a lawyer, get some advice. But if you have your head around the process before it starts, you've got a better stead.
Yes, that's right.
Okay. There are out there, aren't there, some guides for people who have been accused of family violence and how to get out of it. I get the vibe there is.
I think there are.
Yeah, and maybe to cause trouble, because gosh darn it, do we get attacked all the time by these groups. We could do an episode on their playbook.
Yes.
Yeah.
Yes.
Yeah.
I know it.
Yes. Well, you come across it all the time.
I come across it all and you go, oh, I know what song sheet you're singing from.
Yes. So maybe stay tuned. We will do one of those so you know what you might be up against if somebody's trying to get out of
and give them a response to it. Yes, because it shouldn't, like, to me, when it happens, I go, oh, yeah, I should have seen that coming, or I actually do see it coming, and I can tell my client, listen, the next thing's probably going to be this. And it just makes you feel so much safer when and they seem to be so much less powerful when they're just doing predictable things.
Yes.
So that would be a good podcast, Laura.
Wonderful. All right. Hopefully this was helpful to anyone. Again, it's general advice only. You must go see a lawyer. Do what it is that for each individual case, and keep safe.
Yeah.
Okay. Thanks, Mum, for that one.
That's okay, darling.
Thanks,
Bye, everyone.
Bye.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.